Please, Your Lordship. Your Lordship, I beg to mention item number 14, 15, and 16, Your Lordship.
You're for?
I'm for the respondent, Your Lordship. 14, 15, and 16, they are connected matter, Your Lordship.
Cancellation of bill.
As well as item number 13, my lordship. Item number 13 is also connected.
Connected.
Yes, sir.
What about 17?
17 is from a...
Oh, you're also.
It's not connected matter, but it's similar, Your Lordship. Similar, Your Lordship.
Does it comes from it arose out of the same case?
No, Your Lordship. 13 to 16 is from the same charge sheet, Your Lordship.
All NDPS matters. Yours is also NDPS?
Yes. Submission will be same, more or less.
So from 13 to 17, you are for?
Your lordship, I'm for the petitioners.
Pre-made by the respondent seeking accommodation on grounds of personal difficulty, the same not being objected to by petitioner. That is adjourned. This is same after 2 weeks.
Please, please, your lordship, I beg to mention item 12. Bring for 2 weeks' time, your lordship.
Pre-made by the appellant. This is matter after 3 weeks.
Thank you much. Please, your lordship, I beg to mention item number 11. Lordship, let it come after a week.
Number 11?
Number 11, your lordship.
Your Lordship, even in the last occasion, they've asked for time, but then
Oh, you are, yes.
For
You are
respondent number 4.
number 4.
Yes,
only
your
clarification is needed with regard to the land measurements, Your Lordship, by the GHEDC.
You have already,
Partly heard.
you have not yet completed your argument.
Yes.
How many respondents are there? I think quite a number.
I am the seller, she is the buyer. Thanks to the district council.
But you will be the main respondent.
It's required by the GHEDC to clarify with the land measurements, Your Lordship.
This is also to 2022 matter.
pardon, your lordship.
What is your excuse?
I'm having the conducting council is having some personal difficulty, therefore let it come after a week, your lordship.
Okay. On pre-made by the respondent 4, seeking accommodation on ground of personal difficulty of the learned conducting council. Matter is adjourned. This is after 2 weeks.
Bless you, lordship.
Yes, miss, tell me.
Lordship, I beg to mention item number 4. There are 2 matters listed together in item number 4.
Yes.
These are those Nehu matters,
Yes.
Lordship. So Lordship had heard some similar matters, but of course each has its own different story. So I was praying, Your Lordship, that in these 2 matters also, because they are not identical, so we may be allowed to file a written argument in the meantime, and then Your Lordship may kindly take it up after 2 weeks.
Why would you file a, you see, you have not even advanced your oral argument.
Lordship.
Then you're filing a written argument on what basis? You see,
Lordship, because your Lord...
Written argument would naturally be only a brief synopsis of whatever you have argued in court.
True, Your Lordship, but Because if your lordship remembers these matters, because there are a lot of facts and figures. So if that is
you
placed
see, if you
in a
want,
synopsis before
if you
your
wish,
lordship,
you see, if you wish to file a, a compilation, if you wish to file
Lordship.
any written materials to support your case, that's fine. But that should not
Lordship.
be construed as being a written argument as such.
Lordship. Only so that we don't take up too much time of this court, because again, in these two matters which are listed together, they are not identical, your lordship.
Then why aren't they listed together?
That is why exactly I was pointing out, your lordship, because it cannot be argued together. It has to be argued separately.
But they are, I mean, separate cases in any case.
Exactly, your lordship. But they have been listed together.
Anyway, so what you do is, you see, in any case, it makes no difference. If you argue, you will start with the first one and then you continue with the second one.
Lordship, that is why I said we'll file two different, if your lordship
That's
pleases,
up to you.
synopsis, so that because the facts and the other things are different in both cases, so that can be placed before your lordship for.
But please do it. Mrs. Sen,
Lordship.
I want this matter at least to be over and done with by the end of this year at the most. If not,
Lordship.
next year I will recuse.
Lordship,
Obviously,
this
kind
month,
of
right?
adjournment. We have not started with the question of written argument without submission.
That's what.
Anyway, my lord, I
Lordship,
thought
I
it will be
can
taken
argue
up.
the
The last
matter.
order,
My learned
last
friend
order of
knows
lordship
that
was
these
very
matters
reluctant.
we take-
Obviously, the oldest matter, I think, 15.
Yes,
Lordship,
you're
because
putting the
lordship
court,
has heard these matters.
putting the
earlier
court in a
also.
predicament.
Lordship.
Fine, but no adjournment.
Lordship, even today I'm not seeking an adjournment. When the matter comes, I can start with the first one. I'm only saying for the convenience of everybody, Lordship, because then we go
This
through.
after written argument, this can be filed.
No, it's not a written argument. Let's call it synopsis
Fine.
for everybody's convenience,
1 week then.
since it's listed together.
Today is
Today is, my lord, 12. 12 September.
we'll have it on 24th.
24th.
Lordship.
24th, lordship.
Tuesday.
My lord.
Ms. A. Paul Leonard,
Lordship.
senior counsel appearing for the petitioner, has sought for accommodation on grounds of personal difficulty. It is reiterated that this matter is a very old pending one and the parties are requested to ensure that the same is taken up for hearing and expeditiously.
Obliged, Lordship.
Be that as it may, matter is fixed on the next date with no further adjournment.
Lordship.
No further adjournment.
Obliged.
This matter on 24th.
Both the same, both the court.
Lordship, and these two matters may be separated kindly.
No,
Lordship.
you see, like I said, it makes no difference. It makes no difference. You start
No,
with
but
the.
it cannot come as Lordship. It is not even number 4 and 5. It is in 4 two matters.
See, but look, Miss, look at this. It's the numbers are different. It is 161 and 162.
Lordship, and if they were identical matters, then yes, they can be listed together. They are totally different matters, totally different prayers.
Lordship can hear one matter.
It is just a question
That's
of.
why I'm saying
it
on
is-
the next two cases,
it is-
Lordship, the registry may kindly list them separately. That is my humble point.
What difference it makes?
It's just a question of.
That is for
It's just a
everybody's
question of.
convenience.
It's just a question of serial number.
Obliged.
But we'll, as Mrs. Sen said, we'll take it up separately. It doesn't matter. You
Lordship, it has to be
first
that
you,
may kindly be indicated.
you can start with the first one, and then we'll continue with the second one.
Lordship, I'm very sorry to say, Mr. Sen has been saying from day one when all these 7 matters were clubbed
She's not
together that
arguing
they
the
are
case,
similar.
my lord, coming
We
over.
spent 3 years now trying to separate because now your Lordship has
Separate it,
been
man. It
hearing
doesn't
these
make any
matters
difference.
separately,
I never
passing
said-
judgment
I never
separately.
said-
So again,
I
I'm
don't
very
understand.
sorry about those 2 matters.
In
being
any
taken up
in
here
any
at the
case,
court.
in any case, no common order will be passed.
Lordship, that may kindly be indicated.
Only thing your lordship takes on the matter, my lord, nothing
We
else.
spent 3 years on
That's
this
the way
very
it has
issue
been
that all matters are similar.
That is in everybody's mind.
Well, only the problem is here, my lord. At this, it's very difficult for us to retain. Today morning, I have gone through the brief, came ready. Now again, it will come. Again, I'll have to refresh. This is the problem we have.
That's
At least it is informed, my lord, 1 day before, my lord.
that's the seems to say that's the peril of the profession.
My lord, I know, I understand. We are bound to do it. Obligement.
Thank you.
Obliged, Lordship.
Daily list item number 1.
This matter was adjourned.
The case was listed last on 27/8.
Premier by the parties. This is matter of the 4 weeks.
Apply, Your Lordship.
Item number 2.
May it please Your Lordship. Lordship, we have submitted the case diary as well as the pen drive, Lordship, as directed, Your Lordship.
Oh, that is that.
Lordship, yes.
Dawa case.
Yes, Your Lordship, yes. The pen drive is along with this case diary, Your Lordship.
Do I have to view it here in front of everyone, or do I do it?
Lordship,
Do I do it in my chamber separately? What do I do?
let it be in the camera, Your Lordship. In the camera, Your Lordship, within the boundary of Your Lordship.
Mr. Sona, anything else?
I'll just refresh myself, my lord, to recollect.
In any case, I've heard the parties.
Yes.
Lordship, yes.
I recall what has been submitted.
Yes.
So for the state is concerned,
And the CD is has been
Lordship,
produced.
My lord.
so far the state is concerned, Your Lordship, we are relying on the statement of the injured, Your Lordship. The statement of the injured is very clear, Your Lordship.
So only one point, my lord, I guess. My lord, in addition to what the state has produced as a pen drive or a CCTV footage of what is happening on the dhaba on the very night. So in addition to that, I have a CCTV footage of the Juai Civil Hospital where the
Lordship,
victim.
accused has no right at this stage, Your Lordship.
Yes, it's not
Has
because
no
you see,
right
that,
at
that
this
has to
stage,
come
Your
through the IO. If you have anything, you have to convey it to the IO, and he'll put it on record.
We have already conveyed, my lord.
But is it acknowledged on record?
Yes, we know. The trial court has already
Then
noticed. But this thing has not been brought on record by the IO.
if the court cannot take cognizance of it, then it's pointless. Just become a video show.
So only, my lord, only thing I would like to submit in support in support of my contention and in 2 citations which my lord will kindly allow me to place. Regarding the right of the petitioner. I'll just point out the para, my lord.
Para, just tell me the para.
Page 21,
No, para
para 89, 90,
89,
89,
90.
90, and then sub para 90, 112, para 112,
this one.
para 112. Page 21, my lord, 112.
This one. Confusing. Page para. This is para 112.
112, 112, 100, next page, page 22, 113 and 114.
Para 89 is page 81.
21.
21. Para 89, 21. Para 90.
Yes, para 89, 90 and 112, page 21 of the judgment.
Why did it skip from 90 to 121?
It has been written like that. The Sapara, it's him. Sapara of 90.
Oh, this is Sapara.
Sapara, my lord. And then page 22, Sapara 113, 114.
This is all Sapara of
Yes,
90.
yes.
Yes, yes.
It's all settled, Your Lordship.
And then secondly, in the on the point of cooperation of the petitioner. In this para 11 and 12. Para 11 and 12. Next page.
In fact, Lordship, learned session judge has given his finding, Your Lordship, at page 108 of the bill application, Your Lordship. Page 108, Your Lordship.
Page
108, Your Lordship. Oh, Lordship, I'm sorry. In the case diary, Your Lordship. Page 108, Your Lordship. The case diary is here, Your Lordship.
This is a copy of the case diary.
Lordship, yes. Kindly come to page 108, Your Lordship. Para 13 of that order passed by the learned session judge, Your Lordship, rejecting the second bill application.
These are all
Lordship.
well settled principle of bail.
Lordship, yes.
We need not go.
All those, Your Lordship.
So let me go through this.
Yes, my lord.
And I'll pass these orders.
Apply, Your Lordship.
Obliged, my lord.
Item number 3.
It please your lordship. Lordship, in the last date in this case, your lordship has passed an order for producing the case diary in this case. So lordship, I have the case diary here with me, but before producing the case diary before this court, lordship, I'd just like to make a small submission if your lordship permits me.
Yes.
So lordship, the brief facts of the case is that on the 26th April of 2024, the complainant in this instant case, who is Ajay Singh J. Rasotia, complainant in the FIR, he was giving routine orders to 15 sepoys. 15 sepoys. He is the Hawaldar Major of Delta Company. So as was his routine lordship, he was giving orders to 15 sepoys. At that point, lordship, one of the accused person, one of the sepoys, who is the co-accused in this instant case, he is Lance Naik Singh, lordship. So he started arguing with the complainant. He started arguing. So lordship, seeing the co-accused arguing, even the accused person, whose name is Ajay Singh, his name is also Ajay Singh, it's similar to the complainant.
Complainant who Ajay Singh.
Yeah, Ajay Singh J. Rasotia is the complainant's name. And the name of the accused person is Ajay Singh. So lordship, even he started joining and he started using verbal slangs. He started using slang languages. So hearing the altercation, lordship, the situation got out of control. So as a result of that, the complainant went to call the senior officer of the camp. So lordship, but however, while he was approaching on the way to the office, a scuffle arose between the co-accused and the complainant. As a result of that, lordship, hearing the commotion, the senior officer, who is Rajneesh Kumar in this case, he came, he saw the scuffle. So lordship, so he asked, the senior officer, he asked as to what is the commotion all about, commotion. So at that relevant point, lordship, the accused and the co-accused said that they no longer want to continue in the service. And they were stating the reason that 6 months prior, while they were continuing their service, they had asked for leave from the complainant, but the complainant did not give the leave. So as a result of that, they no longer want to continue the service. So lordship, what happened is that the senior officer, he started asking, he gathered all the sepoys in the compound as well as the accused and started asking to give them in writing as to what happened in the case. start asking in writing. So Lordship, at that point of time, as they were giving their writing, suddenly the light went out in the camp, and within a period of 3 seconds, the accused person, he took out a machete from his room, and he went towards the complainant and he struck with the machete on the aiming at the neck. But however, the complainant saw the accused person coming and he just shifted. As a result of that, the blade got diverted and it hit him on the shoulders. So Lordship, my brief stand in this case, Lordship, my humble submission in this case is that, firstly, Your Lordship, if Your Lordship will come to the synopsis in this bail application, Lordship. Your Lordship may kindly come to the at line number 14, Your Lordship, to save your time, Lordship. If I may read, Your Lordship. While discussing with the complainant, then it turned into argument and accidentally dashed with the rifle on his shoulder. Lordship, the bail applicant here is claiming that the attack was made by a rifle, by dash of a rifle. But however, as per the case diary, I have highlighted, Your Lordship, it was actually in the 161 statement of the accused, he has already accepted that he has went to his room, he took out a machete and he has attacked. He has admitted that. Further, this is fortified by the seizure list, where they have even found the machete as well. That, and going to, Lordship, my second stand is that, Lordship, in para 5 of this bail application, Your Lordship may kindly go to para 5, Lordship. If I may read, Lordship. That the applicant states that his son Shri Ajay Singh was arrested by the Umiam police in connection with the above noted case on 07/05/2024. The accused person is, since the date of his arrest, is languishing in judicial custody. The applicant humbly submits that investigation officer has submitted the charge sheet before the Honorable CJM Court and same was endorsed to herself. Therefore, there are no further grounds to keep the accused person on further judicial remand. Moreover, the co-accused already enlarged on bail, hence the application for the enlargement of the accused person on bail. Here, Lordship, in para 5, the bail applicant is seeking parity, Lordship. But however, Lordship, in the 161 statement of the co-accused, the co-accused has stated that he did not even know that the accused person is going to attack. Because both of them were inebriated. The 161 statement of the accused says that both of them were inebriated during the period. The accused and as well as the co-accused. It was not a planned attack. So, and the statement which has been annexed in this diary of all the sepoys as well as the senior officer, they all corroborates and they say that the co-accused did not attack at all. He has done nothing. He was just sitting. He saw the accused person come and attack with the machete, and then kicked the complainant when he was on the ground. After stabbing twice, the complainant fell down. Then the accused person went and kicked, and after that the complainant became unconscious and was taken to the hospital. And both of the accused and the co-accused ran away. So the co-accused has only seen, Lordship, what has happened and merely ran away. The accused, just a comment. So, Lordship, here in this case, he cannot claim parity with the co-accused who's out on bail. And Lordship, lastly, Lordship, and the third stand is that they were inebriated. They were in an inebriated condition, which only goes on to show their fault even more. So, my humble submission in this case, Lordship, is that although this is already a charge-sheeted case, and Lordship, I will not want to object to it, but however, Lordship, seeing the desperate nature of the accused person in this case, the senior officer was present, all the sepoys were there, and in front of everybody, he has taken a machete, he has said that he is going to be discharged from service, he doesn't want to continue in service anymore, he has taken the machete and aimed at the neck, and the complainant has stated in his statement that he saw the accused person coming to attack him, so he shifted. As a result of that, his life got saved. So, Lordship, my humble submission in this case would be, if the bail application, if the accused person is let out on bail, then he might threaten the witnesses who are in this case. So, Lordship.
So the accused person,
Yes.
as well as the complainant, they are all.
No. The accused person, Lordship, if he's out on bail, he might threaten. Sure.
The accused person is he's an army personnel.
Yes, Lordship. They are all army personnel.
Why is the matter proceeded before the civil court?
Yes, Lordship.
Should have been before the force court or whatever.
May please be your Lordship. Lordship, here's what happens here. As my learned friend has said, to some extent, it is correct. They have argument among themselves. So after that, they have the settlement also. Then prior the settlement, after that, they had argued. After that, this incident happened. So now it is here the question comes here. It is not about the things. Now it's been already for 90 days has been over. Charge sheet was filed after 90 days. So now if you come to the calculation day, it has been as of today that is 100 and more than 120 days. Now the co-accused has been already enlarged, and then where the I am seeking the ground of priority also at the same time, and I am the Indian Army personnel. So that was accidentally happened. Okay, so I would never like to quit the services. As my learner says, I have my service. I am diligently serving to the nation according to the superior of my satisfaction of the superior. So now here, since co-accused has been already enlarged, so now my humble prayer before the honorable court is to grant the bail, and I will prove my innocency during the trial. That is that. Then my humble prayer before this honorable court to please grant the bail and maybe put any kind of strict conditions so that I can prove on my can and I can join my duty and I can service to the nation diligently.
I'll go to the case now.
Yes, Lordship. Must.
So I've heard the parties. I'll pass the orders.
Yes, thank you. Highly obliged.
Item number 5.
In this matter, I'm praying for some accommodation, Your Lordship.
Plea made by the counsel for the petitioner seeking accommodation. Matter is adjourned. List the same after 4 weeks. No further adjournment will be allowed thereafter.
Obliged.
Item number 7.
So I have similar prayer, Your Lordship, in this matter as well, Your Lordship.
Seems you're not interested to pursue your case. I said it seems you're not interested to pursue your case.
Your Lordship, in this matter, we are required to seek some instruction, Your Lordship, from the petitioner.
You intending to withdraw this petition?
No, Your Lordship, there's some instruction that we have to take from the petitioner, Your Lordship.
7 and 8 are connected matter, Your Lordship.
7
and 8 are connected, yes, Your Lordship.
What is this case about?
It's regarding the teacher's matter, Your Lordship, yes, Your Lordship.
Teachers, no doubt.
Regularization.
Regularization, Your Lordship.
Regularization.
Yes, Lordship.
Since when have you been in service?
Lordship.
You've been in service since when?
Lordship, actually, I don't have the brief with me, Lordship, so.
On pre-made by the petitioner, seeking accommodation on grounds of personal difficulty, and Shabi. On pre-made letter of counsel for the petitioner who has sought adjournment on the ground that he is not prepared to be heard today, that is adjourned. This is the same after 3 weeks.
Hello, Your Lordship. 7 and 8, same order, Your Lordship.
Item number 9.
My lords, this is that
Yes, Mr. Dev, you're supposed to.
Lordship, in fact, sorry, Lordship is pleased to take the compilation which we had filed. I also.
I think there's still some.
No, Lordship, actually, in fact, it was not pointed out in the Challan itself, Lordship.
Chart.
Yeah, Lordship, we had filed a chart indicating payments. And Lordship is pleased to come. I'll just try to give an example, Lordship. Page 4 of my this chart, Lordship.
Page 4 of the chart of the compilation.
Lordship, it's a chart indicating payments, contributions made by the petitioner.
Yes, yes.
Yes. So page 4 of this, Lordship. So, Lordship, by way of an order of June 2023, the bank account was defrozen. Lordship will kindly see page 4. Lordship, this is the right on the top right hand corner, generated on 6/7/2023.
Yes.
Then Lordship will kindly see in the table, Lordship, total members 25. This is the total number of employees.
Yes.
Thereafter, Lordship will see wage month, March 2023. So this is the month for which the contribution has been made. Lordship, there was a delay because the account was frozen, so it was done in after the account was defrozen in July 6th. Lordship, the amount which has been the payment has been made on 6th July. If Lordship is pleased to come to the next page, Lordship, page 5. Lordship, here Lordship will kindly see same 25 employees. The amount has been mentioned, total 1,28,000. And thereafter in the table, Lordship.
This is for the month of?
For the month of the same March, Lordship.
March.
For the month of March 23, 25 employees. Employer's share of rupees 5,000 plus rupees 10,000 plus 636.
March 2023.
At the end of the page, Lordship will kindly see the total amount which has been given by the employer for the 25 employees is 32,043 rupees for the month of March.
By employer or employee?
By the employer, by the school, Lordship.
By the employer.
By the school, yes. And thereafter, Lordship, if Lordship is pleased to kindly come to the next page, page 6. This is the electronic challan which is generated again for the month of March 23 itself, Lordship. Wage month, March 23. And the third serial number, Lordship, in the table.
Yes.
Total numbers is still 25 itself, Lordship. This is the e-challan which is generated from the online, and kindly see chapter page 7, Lordship. This is the individual employees who is earning how much. So Lordship, if Lordship is pleased to see the, for example, serial number 1 Miss Bahin Lavinia Lingdo, gross salary of rupees 4695, Lordship. So the contribution which is remitted, Lordship will see EE, table marked as EE.
Yes.
Plus EPS, this next table,
yes.
563 plus 391.
So what is EE?
Yeah, this is the employer's contribution.
No, Lordship. Employee,
yes.
double E.
Yeah, double E is employees.
Employee.
Employee. Yes. Double E is employee.
And EPS is?
And ER is employers.
Where's the? Oh, ER is employer.
ER, employer, and EPS goes to employees pension scheme. Pension schemes.
So, no, we are talking about contribution now.
Yes.
So this EE is employees.
Employees.
Double E is employees contribution.
Contribution. And ER is the?
ER is the employer's contribution towards the EPF fund, and EPS is the contribution towards the pension scheme.
Pension scheme.
This is by the employer.
Employer comes with two segregation, Lordship.
employer is for about
Yes, for
after
employer,
12%.
employer will contribute this EPS and ER.
ER, yes, 12% and 12 out of 12%, it is 8 point something and 3 point something.
Is from the school.
So it's you know, if the employee had contributed 563,
Yes.
the
Yes.
employer also would contribute
Same
563,
amount.
Same
So
amount.
but divided
391
into
plus
two
178.
segments.
Two
Some
segments.
goes to the pension scheme, some goes to the fund. So Lordship, all the way till the current Lordship.
Yes, this is what is see this was the query of the court, but
Yes,
nobody could have
probably with the
nobody
full-
could explain to the
Lordship, yes.
to me the other day.
Sorry, Lordship. This
Lordship, last date I was little late, so
full forms because I tried a lot online to find out what is the full form of EE and but
and EPS Lordship, it is for much to make Lordship more clear is that what happens Lordship, out of the 12%, 8 point some 37% it goes to the pension schemes for the pensions of the beneficiary, and 3 point some percent is there that goes to the provident fund. So that is the pension scheme goes higher in if you see the segregation Lordship, the pension amount goes higher and employers contribution towards the provident fund it goes little lower because they contribute towards the pension schemes. So 12% is equal share.
Yes.
So this is
But in any case, on superannuation, the employee
will get pension
and
once
and the GPF.
Yes, and the GPF also.
CPF.
It's yes, provident fund pension. Provident fund. It is employers provident fund.
Employees.
So CPF is contributory provident fund and it is employers provident fund. So on superannuation, employee gets employers provident fund as well as monthly pension schemes or pension also. So it has to be the school has to see or the organization has to see that the pensions are on regular deposits. So.
So just to point out one more aspect, Lordship, this order was passed to file this chart on 21st of May. So at that point, till that point of time, Lordship, we had paid till the month of May. If I can just point it out, Lordship, page 83 of the chart.
Yes.
Lordship, page 83, Lordship will kindly see in the third column, wage month, May 2024. Lordship, this was paid on, Lordship will kindly see upload date time on 14 June at 16:09 p.m. So only, I just wanted to point out, Lordship, total number of members has come down to 16 now. So I have, in my chart at paragraph number 3, I have explained which employee has joined when and so on and so forth, Lordship. And similarly at page 84, Lordship will kindly see employees who are working in the month of May 2024. For example, serial number 1, Catherine Mary.
These are the employees as on May.
As on May 24, Lordship. So if I can just assist, Lordship, kindly come to page 81.
Yes.
Lordship, for each month there are 4 documents which we have enclosed, Lordship. This is the payment confirmation receipt at page 81 for the wage month May 24. So in the next page, Lordship, again for the same wage month of May 24, page 82 is the combined challan.
Okay.
For the same month, Lordship. Dues for the wage month of May 24 on the right corner, Lordship.
Yes.
Then at page 83, this is again for the month of May 24 itself. This is the electronic challan which is generated online. Wage month May 24. And lastly at page 84 and 85, this is the individual contribution and all that. So also will kindly see at page 84, serial number 1, Catherine Mary Siabong. Now her wage has increased to 25,000 gross. Serial number 1.
Yes, yes.
Gross 25,000. So accordingly, Lordship, we have employee has contributed 1800 rupees. We have contributed another 1250 plus 550. So it is as per the wage, Lordship.
Okay.
Because in between there was a pay revision, so I have explained all of that in the. So as on today, Lordship, ever since the bank account has been frozen from the month of June last year, we have been making the regular payments in time, Lordship.
Have you filed your written argument?
We have filed it, Lordship. We have filed it.
Lordship, just I'll draw your Lordship attention to page number 5, Lordship. That is why I was initially I was little bit means I was
page 5.
Because of which I was little bit skeptical.
Page 5.
Page 5, Lordship. It is dues for the wage month of. It is not mentioned.
This is March.
That is because of the Xerox problem, Lordship.
No, earlier he had clarified. He said March 2020.
So for each page, each month there are 4
March
documents.
2023 or March 2024.
23. Lordship, will kindly come to the previous page.
Yes,
March
yes, yes.
20. So for each month there are 4 pages, Lordship.
Yes, March 2023. That's in page 4.
Yes. At page 5, I think it has got cut. Lordship, even the barcode is half cut. Probably that's why the part could not be.
Yes, so that's clarified.
Lordship, yes.
Anything else?
Lordship, yes, Lordship. Because it has not come the dues for the wage month of, so I was under impression that since it is not reflected for which wage month they are filing, so
let me apply my mind to this matter and go through this. I'm still at sea of how to make these calculations. What is required?
Lordship, it would have been much easier, Lordship, filing all the challans. It would have been much easier, Lordship, that for which wage month that suppose, Lordship, I'm giving these are the evidence is there for better understanding of Lordship that March 23 the amount the date is the date what date I have filed. Suppose I have filed on 12th of March. For 15th of March is my due date, so within 12th I have filed. So March 12th, this is the amount. Simple, no need of entire employees. For the March 23 date is 12th, amount is deposited. For 24 employee or 25 employee, this is the amount. So if this that is the segregations made, I was asking
that
because
there, that is there. That is exactly what we have placed. For each month, there is a now there are no more Lordship, physical challenge. It's all paid online. So Lordship, for example, for the month of March, there is a payment confirmation receipt which is generated online, which gives the date on which the payment has been made, the month for which the month payment has been made, and the total number of employees along with the amount. For the same wage month, Lordship, there is a combined challan which shows.
This is only to prove a point that you have been making contribution as far as the employer is concerned, yes, and as well as the employees.
I am saying for the Lordship's better understanding, because Lordship, suppose for annexure 1, Lordship, there is a payment confirmation challan. Then Lordship, there is a subsequent annexure is there, page 9. So Lordship has to go page by page to find out that each month is paid or not. So for them
that's why I have given the table also at page 2, indicating the Lordship is kindly pleased to see the table at page 2 just for fun. The table at page 2, Lordship, kindly see.
Yes, I think this is
the amount. This is the who has been relieved from service, who joined, all there, Lordship.
So this total amount is what at page 2?
This is the total amount, employee plus employer, Lordship.
Okay, employee.
Total contribution.
Good. That so should have been clarified. No? Employee plus employer.
Yes. Total remittance, Lordship.
Yes, yes.
The total remittance.
Yes, I think that's.
Lordship.
We'll see. Heard learn counsel for the parties on conclusion of the hearing, as well as the submission of the written argument and necessary papers. The matter is now reserved for judgment.
Lordship, I am placing two judgments, two judgments, Lordship, with regard to my final argument.
You have not done that in your written argument?
Lordship, during that time I have not placed, in my written argument I have not placed. These are the two judgments I am relying, Lordship.
Much obliged.
Much obliged, Lordship.
supplementary list, item number 1.
Your Lordships, I kindly pray that this matter may be taken up at the end of the board, Your Lordship.
This is the bail matter, my lord. Okay. And section 21 NI Act.
End of the board.
End of the board, my lord.
From daily list, item number 1.
Lordship, I have two submissions to make in this appeal. First, Your Lordship, by order dated 21/8/2024, we were asked to obtain a certificate of posting from the concerned post office, which we have done, and in support of that, we have filed one additional affidavit of service, and annexure 1 is the postal certificate issued by the concerned post office. So, in view thereof, Your Lordship, service to respondent number 4, 7, 8, 10, 11, and 13. And Your Lordship, my second submission, Your Lordship, so far this first one is concerned, Your Lordship, since nobody has entered appearance on behalf of the respondents, save and except respondent number 1.
So now, since the agenda, let us be clear. So as of today,
Lordship,
all the respondents
have been served. Served. Duly served. And only respondent number 1 has put up the appearance. Rest of the respondents have not put up any appearance. So, in view thereof, Your Lordship, I'll pray the matter should proceed.
We can wait for, you see, we can wait for some time. Let
Yes,
them,
no, I have no problem.
Since they have received
Yes,
notice.
yes,
the-
I have
Mr.
no
Jha, are you in this case?
My lord.
You are for?
For respondent number 1, my lord.
Oh, you're for?
Respondent number 1.
And Your Lordship, my second submission is with regard to the order dated 17/5/2024, passed by this honorable court, who the bench which has taken up the motion hearing. The writ appeal was admitted, and further an interim order was also rendered, that is, during the course of argument, learned senior counsel appearing for the corporation submitted that the respondents have not been engaged in any sanction post and they are continuing their work duty for 3 hours per day till date. Learned senior counsel fairly submitted that these persons have been working for several years as part-time employees, and unless sanction post exists, their services cannot be regularized. He further submitted that there is a disputed question of fact involved and the same could not be agitated in the writ petition, and the order of the learned single judge in granting the relief is not correct. Taking note of the submission made by the learned senior counsel that the existing person will not be disturbed from their service till the disposal of the writ appeal, let notice be issued to the respondent returnable by so and so, Your Lordship. So, Your Lordship, the bench have taken has passed the order that their services should not be disturbed during the pendency. Your Lordship, in view of this order, as a matter of fact, Your Lordship, the writ petition filed by the respondent herein, that was dismissed. Your Lordship will come to page 173 of my writ appeal, para 8. Para 8.
Yes.
The writ petitioner, on entering this engagement, therefore, were well aware about the nature of the employment and also as to whether they were to be eligible for regularization. In the backdrop of these facts, the appointment of the writ petitioners as part-time workers stands on a different plank altogether from the 26 regularly appointed person referred thereto, and as such no parity can be claimed by the writ petitioner. It is also settled law that there is an estoppel against the challenging the nature of the appointment once having duly accepted the same. The writ petitioner, therefore, in the considered view of this court on the terms of the employment, and as the same being not against any sanctioned post nor ad hoc in nature but purely part-time, are not entitled to the relief as claimed. So, Your Lordship, there is no cross appeal filed so far. These findings are concerned. By this finding, the writ petitions were found to be not entitled for any relief. Why I have come before this court, Your Lordship? Because of the direction, some of the direction contained in the paragraph 12 of the judgment, that though the writ petitioner, Lordship, may I read?
Yes, please.
Though the writ petitioner, in view of the nature of their appointment, are not entitled to be considered for regularization in as much as the initial appointment is clearly as part-time worker, to balance the equities, and as it has been submitted that they are engaged for the entire working day, it is directed that the respondent corporation pay the said employees minimum wages as prevalent under law, and therefore, considering the nature of the services rendered by the petitioner, calculate the arrears which will be payable from the date of the writ petition was instituted. Your Lordship, the court, the learned single judge, has dismissed the writ petition because the court found that part-time employees are not entitled for regularization. They are working on the part-time basis, is not under dispute, and it is not under even challenge. What direction was given in paragraph 12? That I should pay them full time.
Minimum wages.
Minimum wages for full time, and calculate the arrears with effect from the date of filing the writ petition, Your Lordship. So, in view of the order which have already been passed by this honorable court, that is order dated 17/5/2024, this direction seems to have been merged with the order of the appellate court. However, Your Lordship, to make it specific, my prayer would be that, Your Lordship, that the direction contained in paragraph 12, in view of this order, be also stayed, Your Lordship. In fact, that is already marched in the order dated 17/5/24.
I think there's a distinction there. As far as the order passed by this court is concerned, it relates only to the continuation of service of the petitioner on part-time basis.
Yes, Lordship.
Which they are continuing. As far as we have not gone through the merits of the case, but it appears that as far as the cause or the case for regularization is concerned,
yes,
that has been decided by the Red Court.
Yes, that was the only thing which was there in the, that was the only prayer which was made in the writ petition.
It could have been a prayer.
Yes.
But again, based on equity, the court has allowed them to continue as part-time workers, subject to
minimum wages, my lord.
Subject to what you say.
Yes.
And on minimum wages.
Yes, this court has allowed, Your Lordship, and they are continuing at part-time basis. I have no problem in that. I have no problem in that.
So what we will do is, we'll leave that aside.
Yes.
What we will do is, as far as this case is concerned, we will confine ourselves only to what is your case as far as paragraph 12 is concerned.
Paragraph 12 is concerned. Nothing more than that, Your Lordship, because I have come before this court on a writ appeal only with regard to the direction contained in paragraph 12. Otherwise, the entire writ petition is in my favor. The decision is in my favor. So, this court, Your Lordship, while admitting the appeal, has noted down my grievances that they are still working, as on date, they are still working on part-time employees. And I am paying them on the minimum wages. And therefore, Your Lordship, though it was not specifically required, because that direction in paragraph 12 seems to have been marked with the order dated 17/5/2024. Your Lordship may observe that, and that has been and so far service is concerned.
As far as we'll examine the matter when the appeal is finally heard.
Yes, Your Lordship.
Respondents, my lord.
You are only for respondent one.
One, my lord.
But the other, Mr. General, the other respondents, they are still working.
They are still working.
Then why have they not appeared? I don't know. Who has represented them in this?
My friend.
Then why you have not seeken?
My lord, those who are receiving, my lord, they are coming and approaching me, my lord.
Okay.
My lord, it's
what you can do.
My lord.
What you can do on the basis of what Mr. Jindal has submitted.
My lord.
That the post office, certificate would confirm that the notice have been served on them. They may have received, they may not. We don't know.
My lord.
You confirm it from them. And then if they are all on board, that would have been
that would have been, my lord,
would be better.
Even, my lord, the respondents here, we are the sufferers. So definitely, my lord, they will be here to defend them.
They would like to contest.
My lord. And minimum wage 6,000, my lord.
So
I will
you
contact
try to seek
them.
instruction?
My lord.
Mr. V.K. Jindal and its senior counsel, appearing for the appellant, has submitted that in view of the direction made by this court in the relevant orders, the notices issued upon the respondents have been confirmed to have been affected, and in this regard, the related service of confirmation received from the post office has been enclosed in the service of affidavit of service filed before this court. Accordingly, it is the submission of the senior counsel that all the respondents are deemed to have been served with the respective notices. However, as on date, only the respondent number 1 has appeared through letter counsel, Mr. Arjha. For ends of justice, it would be proper for all the respondents to be in attendance before this court for the matter to be properly adjudicated. Accordingly, this is matter for hearing after 2 weeks. In the meantime, we will not give that direction, but you do it.
I will be.
Lordship, my second submission, Your Lordship, may kindly be also considered.
We will not touch that. We will not touch that. Let them appear, and we will hear the matter, and eventually,
then in that case, Your Lordship will observe that the prayer with regard to the paragraph 12 will be heard after the entered appeal.
we will hear the appeal.
Lordship, there is one problem, otherwise I would not have. He has filed a contempt against me.
Is it so?
But
contempt would merge with the appeal then?
It is already before Your Lordship. Matter is being examined by this Lordship. And he has filed a contempt against me.
And you make your submission before the the court.
That is why, Your Lordship, I am most humbly praying that that matter is under the direction contained in paragraph 12 is under consideration by this court.
Why would we make that observation when the appeal is before us?
It is already admitted, and the court and one interim order is already rendered by this honorable court.
Then you point out those facts before the concerned court and let an order be passed.
Some observation, Your Lordship. Some observation, Your Lordship, is called for.
Not called for, Mr. We'll take out the matter.
Item number 2.
Your Lordship, the council is on leave.
Council is on leave. Convict is languishing.
It's LSC matter, Your Lordship.
Naturally, so that what does it implies? It implies you are not interested.
Actually, medical emergency is there, Your Lordship. That's why you.
On premier by the appellant seeking accommodation on the ground that the legal aid counsel is unavailable on grounds of personal difficulty. Matter is adjourned. Just the same after 3 weeks.
Item number 5.
Good. We have filed the paper book today, Malad. Just like there's
only today.
A copy also on the other side.
Just now only, Your Lordship, we received it.
We can have this matter after 3 weeks, Malad, after Puja perhaps, for final hearing.
Mr. Estapa, counsel for the appellant, has submitted that the paper book has been supplied, has been made ready only today. To which Mr. Additional Learned AJ has also acknowledged the same. Accordingly, on playmate, seeking accommodation, seeking some more time for this matter to be heard, matter is posted after 3 weeks.
Apply, Your Lordship.
Second call from supplementary list, item number 1.
My lords, on the last date, my lord, I was praying. Yes. one of the grounds that I've taken was on parity, my lord.
Yes.
And I was submitting that there are two other accused persons who were very much similarly situated with me and with the same charges. When they were being granted bail, I was denied the bail, my lord. And my lords have directed me to submit the bail orders, my lord. That I have the bail orders, my lord. So, that bail order, my lord, that is of Darius. That is of Dalias Mali, that is accused number 4. And the second one which I have given, my lord, that is of accused number 5, Tinchain Borlang Rani, my lord. Now, the observations made, my lord, here the situation is like this, my lord. There are 4 persons, my lord. Accused number 1, David Nongsage. Accused number 3, Walam Jingsu, that is me. Accused number 4, that is Dalios Mali. And accused number 5, Tinchain Bond Rani, my lord. Now,
and who's 2?
My lord, now two they are different, because for this purpose, my lord, the role of these 4 persons are very important, my lord, for the purpose of limited to these bail applications only, my lord. Now, David Nongsage is a common friend of mine. We are young boys, my lord. I'm a college student, 17-year-old boy. We know each other. Dalias Mali is my friend from the village, my lord. And Tinchai Bor is somebody whom I know, who is not known to me, but is somebody who is known to Dalias Mali. So now, my lord, the allegation against me is, my lord, I'm not, by submitting this, I'm only saying the version of the prosecution. I'm not admitting anything, my lord. According to the version of the prosecution is that David requested me to procure gelatin stick used in blasting, my lord. I asked Dalias Mali, who is my friend, do you know anybody who does? Dalia says that I know somebody, that is Tinchai Bor. He does blasting of stones in a stone quarry. So now David pays me money 2,500. I pays on to Dalias Mali. Mali goes and pays on to Tinchai Bor Rani. Rani pass on the material to Mali. Mali pass on to me. I pass on to David. Now, the observations made in the bail applications of the other 2 persons is that they are not the person who has directly given it to David, who allegedly have conducted the blast. Second part is that they did not have the knowledge that this material was meant for blasting. My lord, on this ground, there was granted bail, my lord. We have perused the entire evidences, my lord. If the prosecution can show otherwise, my lord, what I'm submitting. Not even one evidence has come that I also knew that for what purpose David Nongsage was going to use this material, my lord. Not even one material has come, my lord. So therefore, my lord, we are a pass-on people. In fact, my lord, Dalias Mali and Walam Jingsug, my lord, they were just the pass-on. There is not even one evidence to show that we got some amount of money out of the 2,500. Nothing, my lord. Pass on and it went to Rani. Rani passed on the material and it went to him. We are just the middle persons, my lord. So, my lord, therefore, my lord, when on this ground, when the bail could have been given to the other 2 accused persons who were also charged under section 120B and section 6 of the Explosive Act, my lord, denying bail to me, my lord. Denying bail to me, my lord. denying bail to me was not called for, my lord. That is one of the ground that I've taken to challenge. That is one of the ground, my lord, that I have come before my lords, my lord. So therefore, my lord, I humbly pray.
On what basis was the order passed as far as those bail applications are concerned?
My lord may see bail application 14th February 2023, my lord. That is the bail order of Mali, my lord. That will be the second last page, my lord. My lord has got after section 6.
Yes, yes.
In the instant case, my lord, in the instant case from there, my lord, that is the observations of the court. May I read, my lord?
Yes, please.
In the instant case, the accused Dalias Mali has abetted the commission of an offence under section 3 of the Explosive Substance Act, the punishment for which is imprisonment for life, with rigorous imprisonment of either description, which shall not be less than 10 years and shall also be liable to fine. Now, the allegation against the accused is that he was requested by Walam Jingsuk Barim to procure gelatin sticks and fuse wire and detonators, which he procured from Tinchai Borlang Rani and handed over to Walam Jingsuk. The accused has been in custody for more than 1 year. Considering the materials on record so far available against the accused person, there is nothing to show that the accused has been convicted by any court or that there is any pending case against him. The offence alleged to have been committed by the accused person is not punishable with death or imprisonment for life. In view thereof, this court is of the considered view that a bail can be granted to the accused person. Accused is granted. So same. I was also never. I was also never convicted. I was never involved in any other cases.
You're similarly situated.
Similar situation, my lord. And now, my lord, and in fact, my lord, in one of the bail order which I've shown to my lord, the special judge herself notes that there is no evidence against me, but PW 21 and PW 2, who are the panchnamas, they said there may be something. She herself says that there is no evidence so far against me. Now, my lord. The observations made in the other Rani's case, my lord, that is bail order 0903/2023. The last page, my lord, I will read. The last page, my lord, because there's some citations and all. She has noted all this. And the last page, my lord, the FIR. My lord has got the FIR. Yes. The last page. So.
Yes.
The FIR was originally registered under Section 120B IPC, read with Section 5 Explosive Substance Act, added Section 121, 121A, 122 IPC, read with Section 3 Explosives Act, and Section 10/13 UPA Act against the accused person. However, after completion of the investigation, the NIA filed charge sheet against the accused person, Tincha Running, under Section 120B IPC, read with Section 6 of the Explosive Substance Act. As per the charge sheet, the accused said to have provided explosive to Mali. However, there is no material that the accused has supplied them to David, or that he had the knowledge that the same would be used for the purpose of causing a blast. In view of thereof, the accused person is hereby granted bail, my lord. Here also, my lord, if you come back little back where we said that I was charge sheeted under, initially the FIR was under 121, 120A, and also same thing. When the when the charge sheet was filed, all these sections were dropped against me also. And the observation made that he did not know that these materials are meant for blasting. That also against me also there is nothing. So in both the scenarios, my lord, and in both the cases, my lord, very similarly situated circumstances, my lord. Therefore, my lord, I would humbly reiterate, my lord, that in spite of this, my lord, denying bail to me.
After this order, you did not prefer any bail application.
My lord, after this, my last bail application, this is the 5th bail application that I've prepared.
No, after this order, after this 9/3 order,
My lord,
did you prefer any bail application?
I have. That's why I've taken the
It was
parity.
rejected.
Yes, my lord.
On
That's
what ground? You
my-
did not take. You did not take the
parity. I have taken, my lord.
Which way it was rejected?
My lord, it was rejected only on the ground that it is my hand. My hand was the first
What
hand.
is that order?
My lord, that is the impugned order, my lord, is at page 74. Page 74, my lord. Page 80 is relevant, my lord. Page 80. My lord, may I read from perused, the second paragraph? Perused the statement of PW21 and PW22, who are witnesses to the reconstruction of the crime scene. As per the Panchnama at Exhibit 22, Walam Jingsuk Barim showed the place where he had hidden the explosive under his bed. However, as per the evidence of PW21, the police conducted inquiry and search in the house of Walam Jingsuk Barim, and as per his evidence, the accused took them to the place where the explosive were hidden and the place from where he had taken the explosive from the vehicle. As per PW22, he did not state anything about the reconstruction of the crime scene and merely state that the police entered the house of Walam Jingsuk Barim while he waited outside. From the evidence of PW21-22, there appears to be discrepancy in the versions of the prosecution witnesses and the narration as recorded in Panchnama at Exhibit 22. However, in my view, these are minor discrepancies. The accused petitioner has not disputed the reconstruction of crime scene in cross-examination and does not dent the prosecution case that the accused had supplied the explosive to A1, who had used the same to cause the blast. The accused has also claimed for bail on grounds of parity with co-accused Tinchai Borlang and Dalias Mali. This court does not agree with the grounds of parity taken by the petitioner for the reason that the accused had supplied directly the explosive to A1 who had caused the explosive. So this is the ground, my lord.
You did not. These witnesses, this PW1 and PW22 were cross-examined. And you did not dispute that in your cross-examination. The reconstruction.
My lord,
of the scene.
My lord, reconstruction of the scene after I was arrested, I was taken there. They were doing the reconstruction. How authentic is the reconstruction? I did not deny because there's a fact. Reconstruction was going on. I did not deny, but the veracity and the authenticity that will come to play later, my lord. But for now, because I cannot afford to deny because there is a fact. Reconstruction was going on. So, my lord, on these grounds, my lord, I humbly pray that my lord, and considering also my lord,
You have enclosed the evidence of this PW21 and 22 in your petition.
Evidence of 21, 22, my lord, no, because depositions, cross-examination, I've enclosed only the charge sheet, my lord.
Do you have any authorities?
I'm sorry, my lord.
Do you have any authorities?
Authorities, my lord, I have one 2024 SEC online, my lord, but this talks about, my lord, bail is the rule and jail is an exception.
That is on the
ground of parity, my lord. On the ground of parity,
on the ground of parity or on the ground of delay in trial?
Delay in trial, my lord. My lord, in the course of the day, I can supply. We just got some. We had to print out, my lord. I'm so sorry to say this, my lord, but some technical problem was there with me. But I can supply. We have the judgment.
You do that in the course of the day,
my lord. My lord, I'll supply this.
Yes.
First, to counter the judgment my friend is placing, my lord.
That was a case where even charges were not framed for 3 years. In the present case, my lord, we have examined 29 witnesses till date, my lord.
Yes.
Out of about 61. 61 witnesses are named in the charge sheet, my lord, but we'll cut it down to around 50 witnesses, my lord. Also, out of that, 29 have already been examined.
So, 61 witnesses,
my lord,
to be cut down
to 50, 52, depending on the circumstances, my lord.
51 or 52. Then,
until date, 29 witnesses have been examined, my lord.
When was the first witness examined?
My lord, the charges were framed on, I'll just give this date, my lord, on 9th of March, 23.
The first witness, when was he examined?
First witness is 6th April 23, my lord.
6th April. And the latest?
Last witness was examined on
29th witness?
5th August, my lord.
5th August.
And the next date is on 16th of September, my lord. Today we are on 12th.
Please.
Now, my lord, as far as the role of the petitioner, my lord, that is mentioned in the charge sheet at page 44, my lord. Page 44 of the bail petition, of the appeal.
(18.3). This has been
18.3.
This has been pointed out by the.
My lord, it was pointed out, my lord. But here he is in direct touch with the main person, main accused, my lord. And he had full knowledge and intention, my lord, that for what purpose this explosive is to be procured, my lord.
Where is the evidence to that extent? Because the petitioner would submit that he has no knowledge of why or how the said explosive would be used. He was just requested to procure the explosives.
My lord, the moment it is explosive, my lord, when explosive we cannot procure for some other, so to say, for decorating it or for doing something, my lord. Explosive can only be used for some nefarious act.
It can be used for blasting a rock also.
But the fact remains, my lord, that ultimately it was used in blast in the heart of the city, my lord.
Whatever happened,
it was fortunate that not much injuries happened, my lord. Otherwise, it has the potential to cause large-scale damage, my lord. Dr.
Mojiga, it's a chain of supply.
My lord.
If fastens again are released, why not third one should be released? They play the same role.
My lord,
he may be at the end of the chain. Just because he is at the end of the chain, why should he be detained if others are released?
My lord, he's a part of chain only, my lord. But lots will see he is in direct contact with, and that is the ground taken by the trial court.
He was something like that. He was in the middle. You want to say that his role would have been taken as is less grievous than others. Do you want to say that?
My lord, if I just point out.
Now the fact remains that all three of them are charged under the same section. Isn't it?
My lord.
So where is the distinction? Tell us.
First
you just overcome that question of parity. Unless you show something concrete.
But I'll only read the accusation against 3, 4, and 5, my lord. Just a small paragraph, my lord. At page 44 to you, my lord.
Yes.
Accused 4, my lord, para 18.4. The accused so-and-so A4 worked in as a pickup driver and as a petty contractor. He was requested by Walang Jingsup for procuring gelatin sticks, fuse wires and detonators. A4 had with him gelatin sticks and he procured the fuse wires and detonators from one A5, a laborer in stone quarry site at Umroy, and thus he committed an offence under so-and-so. Number 5, the accused so-and-so came in contact with A4, who used to come to the stone quarry for loading and unloading the stones. So-and-so requested him to get fuse wires and detonators as A5 used to carry out the blasting in the quarry, and there was no dearth of fuse wire and detonators in the place. He helped in procuring the material used for blasting and thus committed an offence under so-and-so, so-and-so, so-and-so. So, my lord, the only difference is they are at the end of the chain, my lord, at the bottom of the chain, but he is just the second person in the chain, my lord, with the person who actually carried out the blast.
No difference. Only thing is that he supplied, he delivered. He was the delivery man.
He was the delivery man.
Yes, so that is.
My lord, kindly notice, my lord, he is the person who delivers the complete package, my lord, because A5 only gives a fuse and wire.
Yes. You see, what would be material?
My lord.
Is the person who has supplied the explosive. This
A4.
A5. He was the one who has supplied. He should have been the one who should apply prudence and inquire why you would need it, what is the purpose, and all these things. He did not. He had simply given. So, as you have observed just a while ago, that explosive cannot be used for decoration. So he would also be in the same position to understand the gravity of the situation. But eventually he was let out on bail.
My lord, as on today, the circumstances, my lord, more than 50% of the witnesses have been examined.
Anyway, that's beside the point. Just because 50% of the witnesses have been examined doesn't mean that you cannot.
Delivered the complete. He will be responsible, held, more responsible because he delivered the complete package, isn't it?
Well, in my humble submission,
had it been without wrapper and all, that responsibility would have gone
it
down.
was somebody only giving a fuse or wire, my lord.
No, that is what submission gave. Dr. Mojika, he said that he delivered the complete package. So had there been, it was delivered minus some fittings and all, his involvement or the gravity of the things, his offense would come lesser. Do you want to say that?
To some extent.
Anyway, it's on the lighter side. It's
Lots will appreciate that, but as far as how much knowledge he had that A1 is, or whether what was the communication between them, that is the 30 witnesses are still, or 25 witnesses still to examine.
We've heard the parties. I think we are inclined to allow this petition on the even otherwise on the ground of parity. You give us the.
My lord, obliged.
My lord, if you also granting bail with very strict conditions.
As strict as can be.
Very strict, my lord. So that at least it doesn't indulge again something like
there are Dr. Mojika, you know very well. Even as far as conditions are concerned, there are obtained number of direction of cases or even strictures by the Supreme Court in this regard. We have to be within bounds. We are not saying. See, we are not lessening the gravity of the case, so to say. It has happened, like you rightly said. It could have been, what should I say, unfortunate if lives were lost. It is not this.
In front of center point, the blast was carried out.
Whatever the intention whatever the cause, that has to be examined. But that would be in course of trial. In course of trial. Now we are only at the stage of bail, where we have to consider the liberty of a person who is to defend his case. So of course, he has to.
Parity, of course, your lordship will examine, but as far as the question of delay is not there, my lord.
Perhaps.
Because in the right earnest, the trial is proceeding, my lord.
If you consider it on parity, that is good enough. Even delay, the outcome will be same. To be sure, you can offer somebody from your team to be a bailer, so you can monitor him.
You heard the parties? Orders will follow. No, कोई बात नहीं, इसे छोड़ लो. But do it as soon as possible, because we cannot wait.
We'll just go and print out, my lord.
Single.